Thank you, Kathy, and good afternoon to all of you here on the East Coast. And we're hopeful that for those of you tuning in elsewhere, you're having a good day thus far. It is the first broadcast that we've had after the Thanksgiving holiday, and we're hopeful, of course, that all of you enjoyed that and got together with family and friends in whatever way that was meaningful to you. We have a full agenda today, which I'll walk you through. And of course, I'll open things up and moderate as we go along. Allison Matthews is with us. She will be coming to us from our Garden City office and will be addressing some legislation that the governor just signed, a package of bills relating to labor issues. You've heard from me in these last few webinars that I've hosted that we are getting to that point where there is more activity around bill signings. And so we'll have a number of different presentations on that today. Another in that space is from Natalie Vogel, along with Roger Bearden. They're both in our Albany office, and they'll be talking about the Clean Slate Act, which the governor also just signed. We'll shift gears, and Michael Donlin will come on next. He'll be with us from Buffalo, where it is snowing quite a bit, although Michael assures me that it's not too bad where he is. And he'll be covering SEC regulatory updates. Jensen is with us as well from the Albany office. And in her work in the hospitality industry, she wanted to update this group on the New York State Liquor Authority's online permit system and some of the issues that have been manifesting there. And then we'll hear from Paige Carey down the hall from me here in New York City. Paige has been on the program, of course, a few times before, and she'll be covering weight and height discrimination language that goes into effect, or rather that is moving into effect in New York City. And so with that, knowing again that we have a full agenda, let me take a moment to introduce our first speaker. So again, that will be Allison, and Allison is in our Garden City office, and in terms of her background, focuses on public and private sector clients with a focus on labor primarily, though in that context is very familiar with municipal and school district clients, among others, and has been with Bond a little bit less time than I, but I think it's under 2 years at this point, but getting close if I'm right. And we're so glad that you can be on the program, Allison. We're delighted that you can make this time. And I know that you want to update this group on this legislative activity and its implications for all the employers who have tuned in. So please, Allison, the floor is yours.
Thanks so much, Gabe. So if we could go to our 2 slides here, we've got a package of legislation that the governor signed on November 21st. So just about the time when everyone was getting ready to start their Thanksgiving holiday. And I want to make it clear from the outset that this package of legislation only applies to public sector employers. So if you're in the private sector, you get a little 5-minute break till we start talking about some of the issues that are going to impact you. So the first packet, first bill that was signed was continuation of survivor coverage. So this has to do with if you have an employee who was enrolled in the New York State health insurance plan and they pass away, there are certain conditions that allow their surviving spouse and dependents to continue that benefit while they are no longer alive. And there was an issue in the eligibility where you had to have 10 years of service. And what they have said now is that if someone retired, the person who was enrolled was retired on an accidental or performance of duty disability, that 10-year service requirement is waived. And that's consistent with some other provisions in the NYSHIP plan in terms of the minimum years of service to get health insurance and how a disability or an accidental disability retirement impacts that. So it's really just closing the hole. The next bill is a change. So this would be a substantive change. And this is the only bill of the ones that I'm talking to about today that doesn't go into effect immediately. So this one goes into effect February 19th of next year. And the rules in terms of abolishing or reducing employees Typically, we've only had to go on seniority rules when we're talking about competitive class employees, and those same rules have now been extended for non-competitive and labor class employees. So all the rules that you're used to following for competitive, and sometimes your contract will require you to follow them for non-competitive and labor class, but now you have to. And that's not necessarily a bad thing because it keeps it a very objective basis for you to abolish positions. Then the next two are also closing some loopholes. So following the Supreme Court's decision in Janus, the Taylor Law was modified to require, among other things, employers to provide their unions with a bunch of information about employees. And one of those pieces of information was the unit member's address. And it was non-specific. So there's been a lot of back and forth on, is that their work address? Is that our home address? Are we allowed to disclose the home address? And this legislation finally makes it clear that it is the home address, and that goes effect immediately. So if you do get an information request or you have to provide that information to your union, yes, you are allowed to provide the home address. And in fact, you are required to provide that home address. The last piece of legislation is mainly, I guess, for the lawyers in the House. There was a loophole also when you have an arbitration award, that now if you want to move to vacate or modify that award, you have to do it within 90 days. And if you don't do it within 90 days, you've waived your right to do that. The reason why this closes a loophole is that previously someone could move to confirm an award and they had a year to do that. And there's a fee that's associated with going to the court and asking them to confirm the award. And sometimes the party that wanted to vacate the award would just hang back. And when someone would move to confirm it, even if it was after the 90 days, they would cross-file to vacate or modify it and avoid having to file the fees. So this just tightens it up and makes sure that if you're going to move to vacate or you're going to move to modify, you've got 90 days to do that. The timeline to confirm is still that 1 year period. And that is so far the workers' rights package that has been signed recently, and we're keeping our eye on some other ones that are in the pipeline.
Thank you very much, Allison. We're appreciative of the few minutes you've provided here today. And of course, please come back on the program as we move closer to the end of the year. To your point, there will be more that's going to happen. By last count, there are at least 150 bills out there that the governor hasn't yet considered for one reason or another. So with that, why don't I then move to our next speakers? We'll be hearing from two, primarily though from one, Natalie Vogel, who is new to our program. Natalie is in our Albany office, as I mentioned, and Natalie is someone who joined Bond with a focus on labor and employment, and in general has experience in personal injury, malpractice, and other areas that are attendant. Presenting with her will be Roger Bearden, who is back on the program. Of course, Roger has been on numerous times before, and what they're going to tackle is really important legislation. The Clean Slate Act, as many of you are aware, because we've talked about it on the program before, has effects on essentially justice involvement, both from the perspective of felonies as well as misdemeanors, and the implications for the workforce are quite profound. So Natalie is going to be leading this presentation and Roger will be supporting. So Natalie, I'll turn it over to you so we can all learn more and really begin to absorb what the Clean Slate Act might mean for this audience. Thank you.
Thank you, Gabe. Hi, good afternoon, everyone. As Gabe stated, my name is Natalie Vogel, and I am a labor and employment associate at Bond in the Albany office. I put this presentation together today with the help of senior counsel Roger Bearden, and luckily, however, and I'm not sure if it's lucky for me, Roger, or all of you, I will be the one primarily speaking on it today. So I will be discussing the recently signed Clean Slate Act. As way of background, almost 50 years ago, New York enacted anti-discrimination protection for individuals with a criminal background. On November 16, 2023, Governor Kathy Hochul expanded those protections when she signed the Clean Slate Act. As she discussed when she signed the act, these laws are put in place for a variety of reasons, including crime prevention, rehabilitation efforts for those looking to re-enter society after they serve their sentence, economy assistance through housing opportunities, and as we'll be discussing today, provide a greater pool of employees for employers. By signing this law, New York becomes the 12th state to sign clean slate legislation. So New York is among states such as New Jersey, Pennsylvania, California, Connecticut, and a variety of others. The law will not take effect until a year from its signing, so the law will be effective November 16th, 2024. So what does the Clean Slate Act do? It will automatically seal an individual's New York criminal record after a stipulated waiting period passes from the completion of their sentence. I want to place emphasis on New York criminal record, as the Clean Slate Act will not seal other state or federal criminal records. The stipulated waiting period is 3 years for misdemeanors and 8 for felonies. However, if an individual commits another crime or violates their probation or parole during that period, the waiting period will be reset. The Clean Slate Act will not seal sex crimes or Class A felonies, which include first-degree murder, second-degree murder, or first-degree kidnapping, among a host of others. However, if Class A felonies relate to drug possession, they will be eligible for sealing. So what are the implications for employers? Well, job applicants whose criminal records were sealed pursuant to the Clean Slate Act will be able to truthfully say that during the hiring process, they do not have a criminal conviction record. And significantly, employers cannot ask an applicant if they have sealed criminal records, nor can they consider any conviction that is sealed pursuant to the Clean Slate Act when making an employment decision. And as I first mentioned, there are New York laws in place already prohibiting employment discrimination based on an individual's criminal conviction status. Those laws will remain in place and employers must continue to follow them. And I just listed a couple here, primarily Article 23 of the New York State Correction Law and the New York City Fair Chance Act. Article 23 of the New York State Correction Law provides an exception to the general principle that an employer cannot discriminate based on pre-employment criminal background history. Through Article 23, an employer may deny employment based on a criminal conviction record if, after considering numerous factors, the employer can establish a direct relationship between one or more of the previous criminal offenses and the specific job that they are applying for, or where there is an unreasonable risk to the property, safety, or welfare of an individual. And then the New York City Fair Chance Act is only for New York City employers, and that just sets forth additional requirements when making decisions based on an individual's criminal record. And I know this is about the Clean Slate Act, so you might be wondering why I am referencing these. Well, first of all, it's always good to have a nice refresher on laws that you must abide by. But second, once the Clean Slate Act is in effect, New York employers will not be able to consider a sealed criminal conviction record as they now would have under the factors in Article 23A or the New York City Fair Chance Act. So with sealed records, it's as like the crime did not happen at all. You cannot look at it and you cannot consider it even with the factors in these laws. And so there are also some additional reporting requirements for employers if they receive unsealed criminal conviction records in response to a request for conviction history. So beginning November 16, 2024, if you're an employer and you receive an unsealed criminal conviction, you have to provide a copy of that record to the employee and or the applicant, provide a copy of Article 23A of the New York State Correction Law, and provide a notice to the employee or applicant of the right to correct any incorrect information. So this is just letting you know of your future reporting obligations once this law is in effect. And so the Clean Slate Act is not without its exceptions of its own to the general rule that there should be no access to sealed criminal records. One of those exceptions applies to healthcare and human service providers. So the Act preserves access to criminal records where federal or state statute requires certain employers to screen employees to protect vulnerable populations. These vulnerable populations include children, elderly, individuals with disabilities, or just other generally vulnerable populations. And the Act actually helps us out a little bit. It directed the Division of Criminal Justice Services to maintain an up-to-date list on all local, state, or federal statutes that statutorily require employers to conduct background checks before employment. So if you are statutorily required to screen employees, you will have access to sealed criminal records that would otherwise not be available to other employers. So, for example, if there's an individual who was convicted of child abuse, they served their time, they waited the stipulated period for the record to be sealed under the Clean Slate Act, their record would be sealed. However, if the individual then goes to apply to an elementary school, because the elementary school is statutorily required to do criminal background checks on their employees, they will be able to access the otherwise sealed child abuse conviction. But that's not without to say that they don't have to follow any of the other laws in place about conviction discrimination. While the elementary school will be able to consider the conviction, they must also comply with Article 23A of the New York State Corrections Law or the New York City Fair Chance Act if they are a New York City employer. And so here are some general takeaways for you to consider. While the act does not go into effect for another year, it is important to look at your policies, talk to your employees, see what their procedures are to make sure that they are complying with current conviction discrimination laws, such as Article 23A of the New York State Correction Law or the New York City Fair Chance Act. Then it's good to be proactive in updating your policies, training your employees, so you are ready when the Clean Slate Act is in effect. I know seems a long way. November 16th, 2024 seems like a long time, but we all know how fast a year could go by. And then I wouldn't be a lawyer if I didn't say consult with legal counsel. It is important to consult with legal counsel on employment decisions based on an individual's criminal history because you don't want to expose yourself to any additional liability. And then I will leave off saying Roger and I, with our colleague Neela Sikander, drafted a blog post on this topic with some additional information that should be posted within the next day or so. So feel free to access that on the Bond, Schoeneck King website. And then I want to thank you for your time. Roger, if you have anything else that you would like to add.
No, you did a wonderful job, Natalie, and thank you. And we do see some questions in the chat box, and we'll endeavor to gather those and get some answers back directly.
Yes, I really appreciate your time, Natalie, as well, Roger. And the questions that are coming in are very textured and really in the vein of the kinds of procedural issues that will have to get worked out as these standards are ultimately implemented. This is a major change, and we expect this will be the first of or perhaps a few presentations we have on this package, given its broad-ranging implications for the various employers that tune in. So Natalie and Roger, thank you both for this first foray, and you're both welcome back as these issues become more material and otherwise mature. So, and to all of those who raised questions in the chat, as Roger noted, we'll do our best to answer them now or otherwise in an offline fashion. But let me now switch to our next speaker for the day, who is Michael Donlin. As I mentioned, he is with us from Buffalo, though indicates it's just a dusting at the moment out there. And it is a pleasure, Michael, to have you on the program. Michael, for those of you who aren't familiar, is an attorney who has a wide-ranging practice that involves manufacturing, business and transactions, agribusiness, mergers and acquisitions, and there's a significant amount of work involving the SEC. And today, Michael's here to give us updates on SEC regulatory activity that's germane to this audience. So, Michael, with that, we're glad to have you on the program, and please take it away.
Thanks, Gabe, and good afternoon to everyone. What Gabe forgot to mention was that coming out of the Thanksgiving holiday, he thought we could use something to help us fall asleep a little bit quicker and maybe sleep a little bit longer. So he asked me to speak on SEC regulatory updates here. I have a intimidating 15 slides here, but I really wanted them to be for background information. I will not be going into great detail on any one of these regulations because as you go through the SEC regulation process here, I had to go through about 1,000 pages of regulations to boil down this presentation here. So hopefully we'll be able to jump right in and keep it moving along relatively quickly here. So every year the SEC has a regulatory agenda that they put out. This is the process that they look to follow for the upcoming year, which would go through April of 2024. There were approximately 18 proposed rules and 38 final rules that the SEC has had indicated that they were hoping to move forward with during this year. Some of them have stayed on track. Other of them have slipped various ways due to timing issues. The much awaited rules on climate change disclosures have slipped, and now we're not expecting them to be coming in until sometime in 2020, later in 2024 is what my expectation is. I'm focusing on 4 of them that affect public company disclosure. There's plenty of rules that the SEC puts out that deals with investment advisors and broker dealers, investment companies such as mutual funds, private funds. They have a very broad regulatory overview here, but I'm going to focus on the disclosure aspects that impact publicly traded companies. So our first one is going to be talking about the SEC's cybersecurity risk governance rules. These were adopted over the summer, and there's 3 main components of these rules. And I should say that we are expecting to be putting out an information memo on this shortly here, so there'll be greater detail shared in the coming days on this topic here. But this rule, which as I said, came out during the summer, has 3 main components of it. One is a prompt reporting requirement for cyber incidents by public companies. The second is some disclosure regarding the risk management and strategy of the company. And then a third component of it is to describe the cyber governance at the public company here. Quickly going through them on the next slide. On the cyber incident reporting, there is a requirement that when the company determines that a cyber incident was material, from that point forward, you have 4 business days to disclose certain information regarding the nature, scope, and timing of the incident, as well as the material impact or the reasonably likely material impact on the company. That is new disclosure that is required by public companies that will become effective in the middle of next month. On the cyber risk management and strategy, this is going to be an annual disclosure regarding the company's processes for assessing, identifying, and managing material risks from cybersecurity threats. This will become effective for companies whose fiscal year ends after, I think it was December 15th. I have it later in the slides here. So this will be disclosure that will be required for calendar year companies for their very first filing in the first quarter of 2024. In addition to the disclosure regarding risk management and strategy, which unfortunately I fear is going to result in a lot of boilerplate. When you've got 10,000 public companies here, some have done a very good job with developing their cyber risk management policies and will be able to disclose quite a bit. Others, smaller companies or in an industry that might not be directly or as impacted by cyber risks, you worry that this type of disclosure is going to start off strong and then kind of unfortunately take the boilerplate approach here. Hopefully I'll be proven wrong on that. In addition to disclosure on the risk management and strategies, as on the next slide, there is a disclosure requirement also beginning in the annual report for next year regarding the company's governance with respect to cybersecurity risks. And that includes disclosure regarding the board's oversight, as well as management's roles and expertise in implementing cybersecurity policies. As I indicated, the effective dates here. So the material incident disclosure requirements, that's the 4-day reporting requirement that begins on December 18th of 2023. There's about a half-year delay for smaller reporting companies, so that would be in the summer of 2024. And then for the annual disclosures on the risk management and the governance, those, as I said, would begin if you're for fiscal years that end after December 15th of 2023. Most companies are calendar year companies, so they would be covered by these rules with their first filing in 2024. Moving next on to our next topic here is share repurchase disclosure modernization rules. And I don't want to bury the lead here. The SEC has actually had to put a stop on the effectiveness of these rules because of a Fifth Circuit case that came out at the end of October, and just as early as right before Thanksgiving, the SEC postponed the effective date of these rules here. They were scheduled to go into effect for fiscal quarters that began October 1. So for most public companies, that would have been their fourth fiscal quarter, and their disclosures would have been coming up in their next filing in 2024. The reason why that has been postponed is because the Chamber of Commerce filed a lawsuit claiming that the SEC violated the Administrative Procedures Act, and that is unfortunately stayed the rules for this point in time. Just briefly going over them because they are stayed. They were generally just requiring more prompt disclosure and more detailed disclosure regarding a company's repurchases of its securities. Currently, the rules are that a company is required to disclose on a quarterly basis, with the information aggregated on a monthly basis, any repurchases that they make in their company securities. The SEC had first proposed a daily reporting of repurchases, but the final rules were set at a quarterly reporting, but of a daily breakdown of share repurchases. And as I said, those rules have been stayed at this point in time due to that Fifth Circuit case. So I'm going to jump forward here quite a few slides here. Let's see, we're going to go to the one that starts with modernization of beneficial ownership reporting. These are rules that just came out in October of this year and become effective in February of next year. In general, back in the 1960s, the Congress passed the Williams Act, which was kind of in response to hostile takeovers. That requires individuals who acquire more than 5% of a voting class of equity securities to provide information regarding themselves and their holdings. That's called a beneficial ownership report. It's meant to provide transparency to the public regarding significant shareholders and how and why they have acquired those shares. The rules have not been really updated in 50 years since they were first adopted. So this is their first substantive rule change in a long time. Basically, it just shortens a lot of the filing deadlines for filing these beneficial ownership reports. For Schedule 13D filers, it got shortened from 10 calendar days to 5 business days. The 13G filers, it got shortened depending on whether you're a passive investor, a qualified institutional investor, from either 10 calendar days to 5 business days, or from disclosure at the end of the calendar year to disclosure after the end of the calendar quarter in which you exceed the 5% threshold. They also changed the reporting requirements for amendments to these forms. The SEC had required amendments on 13D to be filed promptly. They clarified that to mean 2 business days. And on the 13G filers, are basically institutional shareholders who do not have an intention of influencing the management of the company or control of the company. Think of mutual funds and investors of that nature. They're allowed to file on a short form 13G filing here, and that's why their timelines are a little bit more relaxed than a 13D filer, who are more potential to try to make an influence in the company's overall direction. So they shortened the time frame for amendments for both the 13D and the 13G filers here. The compliance deadlines for this, these become generally effective in early February of 2024. There is some delayed effective dates for certain parts of the rules here. And now you might ask, how in the world did I spend all this time on a 295-page adopting release here, and all we did was change from 10 calendar days to 5 days and stuff? Well, there's a lot of rules that the SEC proposed that they did pass on, and they issued interpretive guidance. So that's where a lot of the stuff in the adopting release is in the form of guidance as opposed to actually regulatory changes with respect to these rules. And finally, the last topic I wanted to talk about is the clawback policies. This was not part of the 2023-24 regulatory agenda by the SEC, but it's a holdover from the prior year, but it does become effective on Friday of this week. So I just wanted to touch on it briefly. This is a requirement that the SEC adopted rules approving changes to the listing standards from the New York Stock Exchange and NASDAQ, which they themselves require each public company to have a policy regarding the recoupment of erroneously paid executive compensation in the event of a restatement of the company's financial statements. That's a lot of information there, and I try to keep it on track. And I hope I didn't throw our schedule off too bad there, Gabe.
No, not at all. And it wasn't tryptophan. You did just fine. And I think everyone is doing okay post-Thanksgiving with the very helpful information that you provided. And please come on to the program again when you have another batch of these updates. There were several questions that came in through the chat suggestive of a lot of interest in what you have to share here. So thank you again, Michael. And let me turn to our next speaker, who's from our Albany office. Jensen's with us, and Jen has a really diverse and interesting practice that involves cybersecurity, hospitality, M&A, property, emerging businesses, agribusiness. It's really a broad array. And in one of the areas where she focuses, hospitality, there's been some activity around liquor authority. And so Jen is on the program to bring everyone up to speed on what's going on with this online permitting system. It sounds like it's not perfect at this point. Please.
Yes, yeah, absolutely. Thank you. Thanks for giving me the chance to be here today. I have 0 slides. And my presentation is going to be much less regulatory. And in fact, I'm going to be talking about liquor and holiday parties, essentially. So I've been doing liquor licensing for 20 years now. And every year, I think it gets a little harder. So it is that season. It is holiday party season. It's that time of year. So I have a lot of clients who are getting ready to cater parties for this time of year. Lots of food and alcohol services businesses are worried about that. And it can be all different kinds of clients who might be getting ready to cater. You know, obviously I have catering companies, but also restaurants and breweries. And I've even fielded questions from, food service departments at colleges. They're having different parties at different locations on campus. And if that party is going to have alcohol and it's being held at a location that doesn't have a liquor license, somebody probably needs to get a special events permit from the liquor authority to have that alcohol service at that event. So there are different kinds of permits. I won't go into everything on them, but there are several times. Some are just for beer and wine. Some are for full liquor if you're going to have a full open bar. And there's different rules about how you qualify for different types of permits. But for today's purposes, just say that all of those kinds of permits need to be applied for through the New York State Liquor Authority's permits online system. So the Liquor Authority had been issuing permits online for the last several years, and the system worked pretty well. However, last month, they did shut down the old system. They unveiled a new system, and it definitely has some issues. So I've been fielding a lot of calls from a lot of different types of businesses who are trying to get permits and are having an issue. So I'll run through a few things that have worked for my clients and I've learned from the Liquor Authority and speaking to them about some issues. I'll fill you in on a few issues that unfortunately only the Liquor Authority can fix. But the takeaway for all of them is that if you're in the hospitality industry, you're going to be looking for a permit between now and mid-January. I would say apply early, as early as you can. That has taken a lot of my clients by surprise, because under the old system, they were pretty confident that if they applied at least 10 days before their event, it was probably going to be fine and the permit would come through in the ordinary course. And 10 days was sort of the rule of thumb. Now, under the new system, with a lot of the issues we're seeing, I would say as early as possible, if this is something you might be applying for. So a lot of the problems that I'm seeing my clients encounter are happening very early on in this process. So if you're new to this new permits online system, you're going to have to create a new login, an individual login, and I won't go through all the steps. There's actually some pretty good instructions on the Liquor Authority's website about the process. But once you've created that login for yourself, you have to link that to your business and your business's liquor license. And that's where a lot of the difficulties seem to be coming in. They call that process claiming. You're claiming your business for purposes of this permit online system. And a lot of clients are finding that they can't. They can't get their login to claim their liquor license through the system. So one thing I've suggested to clients, and it's a little surprising to them, but it has worked for quite a few of them, is you might not be putting in the name of your business right. And clients are like, well, I know the name of my company. I'm putting it in correctly. The Liquor Authority's records may have your business's name different than you think it does. Under the old technology they had, a lot of times in the Liquor Authority's database, they have shortened the name of your company. They may or may not have LLC. They may or may not have Corp or Inc. And they quite possibly have shortened the words that are in the name of your business. And you might not realize that they have done that. And sometimes the way they've shortened it would be very hard to guess. I had a client just recently who finally had success when they realized that the Liquor Authority thought their name was XYZ Rest, R-E-S-T, instead of restaurant. But sometimes I've seen words shortened in kind of unusual ways. I've seen HTL for hotel. I've seen some abbreviations that I never would have come up with. So I've been telling clients who are running into this issue, the first thing you should do is go to the Liquor Authority's website. They have a function in there called the LAMP database, L-A-M-P, LAMP. And it has a search function where you can put in your business's name, your serial number of your liquor license, your address, and you will be able to see how the Liquor Authority thinks your business name is. So that has helped some clients. Sometimes that'll get you over the hump and get you through that issue. So if that doesn't work, some other things that I've been letting my clients know is that if you have two businesses, two corporations or LLCs listed on your liquor license, and you may, a lot of clients do. For example, a lot of hotels have the owner of the hotel and the management company, or you might have a parent and a subsidiary, depending on how your liquor license was applied for. You might have more than one name on there. Try putting in both. That has worked for some clients. Sometimes it doesn't, but sometimes that has gotten them past the roadblock as well. Another thing I've been telling clients, several have run into this, see if anybody else in your business, any of your other officers, for example, have other New York State logins for other purposes. I've had clients who have, for tax filings, for example, somebody else in the business already has a New York State logon that has claimed the business for other purposes, non-liquor purposes. And that has been an issue that I've run into. Now, fortunately, if that happens, that's probably going to warrant a call to the Liquor Authority to help getting that straightened out, but something to be aware of that you might want to ask around within your company if you run into this problem. And unfortunately, the biggest issue, and one that you can't fix at home, for lack of a better term, is the Liquor Authority has acknowledged openly that not all records have transferred correctly into their new system. So the system may not recognize that you have a liquor license. You have it, it's valid, you can see that it's valid, it's unexpired, etc. but the new system may not recognize it. And that's tough. That is unfortunately something that has to get fixed at the liquor authority level. And we have seen clients have a lot of difficulty with that and getting that resolved. So if that happens, that's going to warrant, call to the attorneys, call the liquor. We can speak to some folks there and try to work past that roadblock. So again, takeaway, apply early, apply as soon as possible. And if you are not a hospitality client and you're just having a holiday party and you're having it someplace that doesn't have a liquor license, maybe you're having a caterer come to your office, or you're having a party community center, your local museum, something like that, probably worth a call to your caterer and make sure that they have the permits they need so your party goes off without a hitch.
Jen, thank you very much. And I know that everyone who's listening here will try to work quickly and get things done so that their parties are joyful as they should be. And of course, we're available at Bond to help if there are those hitches. And let's turn to our last speaker for the day, who is Paige Carey. Paige is with us from the New York City office, just on the other side of the hall from me. And we're going to focus on a New York City issue that may have resonance elsewhere in the state, and Paige will get to that. It's about weight and height discrimination and a bill that's going into effect in New York City. Paige, please go right ahead. We're glad that you're back on the program for, what is this, your fourth or fifth appearance at least? So welcome back.
Fourth or fifth. Thanks, Gabe. So just to briefly begin, and Kathy, next slide, please. Thank you. So just as a bit of a background, a broad overview of this law and how it came into effect, on May 26, 2023, Mayor Adams signed this a bill into law prohibiting height and weight discrimination within employment, housing, and public accommodations under the New York City Human Rights Law. And that law just recently went into effect last Wednesday on November 22nd, 2023. Next slide, please. So just as a very general overview of what this law prohibits, going forward, anyone who lives in, works in, or visits New York City is protected from discrimination based on height, weight, or just generally body size in employment, housing, and public accommodations. And a few examples of what that would look like would be refusing to hire someone based on height, weight, or body size, a public accommodation refusing to serve a customer because of height, weight, or body size, or offering different lease terms based on height, weight, body size, different employment conditions. So just a couple of examples of that. Next slide, please. So a couple of exemptions exist to this general prohibition. The law has carved out an exemption for employers needing to consider height or weight in employment decisions, but only where required by federal, state, or local laws or regulations, or where the Commission on Human Rights, which is the entity that regulates this area of the law, permits such considerations because height or weight may prevent a person from performing essential requisites of a job and there isn't an alternative available, or if this criteria is reasonably necessary for the normal operation of the business as decided by the Commission. This bill also would similarly permit such considerations of height or weight by operators or providers of public accommodations. But it's important to note that there's no exemptions available for housing. So you don't have any exemptions there. And overall, I think just generally observing these exemptions, although the law's prohibitions are accompanied by a few exemptions, they're pretty narrow and dependent on allowances contained within federal, state, or local laws or regulations, or as expressly permitted by the Commission. So just important to note that they're not super broad, they're pretty narrow. Next slide, please. So there's also a couple of affirmative defenses available for employers and public accommodations covered by this law where the exemptions are not available. So the two affirmative defenses that are available are, one, if a person's height or weight prevents the person from performing the essential requisites of the job, and there's no alternative action the covered entity could reasonably take that would allow the person to perform the essential requisites of the job. And the second one is if the covered entity's decision based on height or weight criteria is reasonably necessary for the execution of normal operations of the covered entity and its business functions. And again, for housing, there is no affirmative defense available. Next slide, please. Just a quick caveat to note, the law does not prevent a covered entity from offering incentives that support weight management as part of a voluntary wellness program, and the law expressly states this. So just something to keep in mind as a area that's not prevented under this new law. Next slide, please. So as far as key takeaways and best practices going forward, New York City employers should review written policies, training manuals, handbooks to ensure compliance with this new law. And it's likely that there will be edits necessary, just given the fact that there are 2 new categories protected under the human rights law in New York City. And employers may also want to review any positions for which there are height and/or weight criteria to better understand and define the business needs for such criteria, just to better prepare themselves going forward. And as Gabe mentioned at the beginning, just kind of a quick point to note that there is similar pending state legislation, so it is possible we could see this spreading to the entire state of New York at some point in the near future. And that just about wraps it up. Thanks, Gabe.
Of course, Paige, thank you very much for the succinct summary there and for making sure that our audience has a sense not only of what's happening in New York City, if those standards apply to those of you, with New York Touchpoints City, that is, but also about, where this may be going as that legislation Paige alluded to potentially advances. So we've reached the end of our program for the day, but let me make sure that each of you has an opportunity to contact the attorneys who presented. You see the information on the slide right now. We got a bunch of questions today through the chat, and we're grateful for those. We couldn't answer them all in real time, but we will get back to you. So look for those in the next few days. You'll hear whether from me or other attorneys who presented in follow-up. And I will be back with you in December on the 12th for my next scheduled hosting with all of you. And in the interim, you'll be hearing from Kristen Smith. Wishing you a terrific balance of November, and in general, just thankful that all of you take this time and tune in and otherwise are so committed to this program. It really makes a difference, and we look forward to having you back with us in a week.